Hello, everyone, and welcome to Commaciel Carey's webinar on religious and disability accommodations in response to COVID-19 mandates. My name is Lindsay DeSalvo. I'm a partner here at Commaciel Carey in both the workplace safety and health practice and the employment practice, and I am joined today by my colleague, Andrew Summer, who is also a partner in both the workplace safety and employment practices and heads up our office in California. So before we sort of jump into the content, we just want to quickly sort of review what the main topics we want to cover today. The first is a general overview. So we're going to talk a little bit about where we've predominantly seen the issue of accommodation come up in the context of COVID-19 over the past couple of years, and then go through the process of how an employer should consider and evaluate and address a request for an accommodation. Then we're going to get into some more specifics about the different types of accommodation and cover religious exemption issues, what we've seen arise related to requests for a religious exemption under Title VII, then medical exemptions under the Americans with Disabilities Act, and then finally, just some final steps and considerations in the context of the accommodation process and dealing with these different issues that we've seen arise related to both requests for accommodations for a religious reason and for a medical or disability reason. So in the next slide, what we wanted to start with before sort of getting into the specifics is to talk a little bit about where we've really seen this issue arise over the past couple of years. And, you know, a lot of you may have your own experiences with addressing both disability-based accommodations and religious-based accommodations. But where we saw it most often and where we got the most questions, you know, particularly in the last probably 6 months or a little bit more than that, were in the context of employer mandated vaccinations. So as a lot of you probably know, this was a big push from President Biden and his administration. So there were many employers also that decided to go the route of a mandated vaccination to address the safety issues related to COVID-19 and ensuring that, their businesses could continue during the pandemic. And then there was also, OSHA's attempt, the Occupational Safety and Health Administration's attempt to require mandated vaccinations for certain employers that did not, end up coming to fruition really. Based on the Supreme Court's decision, but there has been a big push for employer-mandated vaccinations. And so a lot of the questions that we got were related to employer-mandated vaccinations and accommodation requests, in that context. But it's certainly the case that accommodation requests could be made related to a mask mandate or COVID-19 testing mandate. If an employer requires testing, there may be certain disabilities or religious beliefs that conflict with that. And then the big area that I think we're going to see this now as we sort of transition into a phase where a lot of employers, if they had remote employees, are mandating some level of coming back to the work environment, that we'll likely see, requests for exemptions based on disability or religion related to any mandate for return to work. So in this context, I've already kind of said this, but just to sort of lay it out a little bit more specifically, there are two main laws at play in the area of accommodation for mandates related to COVID-19. And the first is Title I of the Americans with Disabilities Act, which requires that employers provide reasonable accommodation to qualified applicants or employees who have a disability as defined by the law. And then the second major law is Title VII of the Civil Rights Act, which requires employers to accommodate employees' sincerely held religious beliefs. And that can include religious-based objections to vaccinations, to masking. And in both of those, under both of those laws, those accommodations are required to be made unless they would create an undue hardship on the employer. And we'll talk a little bit more detail about undue hardship in a few slides.
And I would just add that you'll want to look at your equivalent state and local laws. I know in California there was a move front to mandate employee vaccinations under Cal OSHA. That effort has been since stalled. But what we're finding is that we have a number of clients that we work with where they have decided on their own they want to continue to mandate vaccines in the workplace. So there will be an issue that we're discussing today about medical and religious exemptions to the employer's right to mandate a vaccine requirement. And then independently, there are other contexts that may be more relevant nowadays as we're hopefully easing into an endemic setting, looking at the return to work situation and exemption requests in that regard, as Lindsay mentioned.
Thanks, Andrew. So on this slide, we've just kind of laid out some of the major reasonable accommodations or the major types of reasonable accommodations that we saw that were evaluated related to a vaccination mandate. But many of these, or at least a few of these, would also apply in the context of a mandate for return to work. Some of them might apply in the context of a masking mandate to which someone requests an accommodation. So the main things that we've seen are first wearing a face mask. I think this is particularly relevant in the context of, a vaccination mandate. If someone is not able to be vaccinated, that there are still steps being implemented if they are in the work environment to protect them and others from exposure. Teleworking has been a big one. A lot of employers have found over the last couple of years that teleworking is something that they're able to accommodate. So that could be an option for an employee who asks for an accommodation related to a vaccination mandate or a return to work mandate, depending on the reason for the request. Potentially being reassigned to another position. It could be the case that, certain positions at the company, you're not really working around a lot of other people, or you're not really working with the public. And so there's some additional protection there if you need an accommodation from a vaccine mandate or a masking mandate. So those are a few of the different types of accommodations that we've seen, particularly in the context of a vaccine mandate, but with other COVID-related mandates as well. And then this next slide talks about sort of what we see as best practices in the context of any type of COVID-19 vaccine mandate, particularly where, accommodations might need to be made. So the first best practice here is to ensure that when you put out a policy mandating something, so whether it's a vaccination mandate, a COVID-19 vaccination mandate, or a mandate for return to work in some way, shape, or form, that when these policies are put out there and when employees are notified of these policies, that they're also notified that the employer will consider any request for reasonable accommodation, and that request will be considered on an individualized basis. And we'll talk a little bit more about that in talking about the actual process for reviewing an accommodation. And then also, before actually instituting a mandatory vaccination policy or a mandatory return to work policy, or really any policies related to COVID-19, an employer does want to make sure that they provide managers and those that are going to be responsible for implementing the policy training and information as to how to handle accommodation requests. So an accommodation request doesn't have to be made using any particular language. And there is leeway given to, when an employer should recognize that a request for accommodation has been made. So managers and supervisors and anyone else to whom an employee may come about a concern needing an accommodation to a vaccine mandate or needing an accommodation to required return to work, how to address that, how to identify that a request is being made if it's not super clear, how to refer that request so that next steps can be taken, who they should contact, if they should contact a specific representative in HR, or if there is like a higher level manager that they should be bringing this to, but making sure that they have the tools necessary so that once the policy mandate is implemented, they can address these accommodation requests as they arise. So now we'll spend a little bit of time going over the initial steps that an employer should take in evaluating and determining accommodation requests. The first step, and a step that I think probably a lot of employers had in place prior to the COVID-19 pandemic anyway, related to the general requirement to have an accommodation process in place for any accommodation request, is to have a specific policy and procedure for how accommodation requests are going to be handled. It should certainly, even if there is already a policy in place, this is a really good opportunity if an employer hasn't already to review the policies and procedures, make sure that, everything is in place to allow a smooth process for dealing with an accommodation request. Again, going back to making sure that the required training and instruction is provided to those who might get an accommodation request, and that employees understand that there is a policy and procedure in place to make an accommodation request. And if it is the case that there isn't a policy or procedure in place for some reason, then that is certainly something that an employer would want to develop. We did want to note here that the Americans with Disabilities Act, or the ADA, and Title VII of the Civil Rights Act both only cover employers with 15 or more employees. I think that is going to be a lot of employers, but the laws are sort of limited to employers with 15 or more employees. However, going back to the comment that Andrew made a little bit earlier, a lot of states and localities might have their own and do have their own anti-discrimination laws that would apply to both disability and, religious beliefs. So even if the ADA and Title VII might not apply to an employer because maybe they're a particularly small employer, it could be that the state law applies because either the number of employees is lower than 15, or a lot of state laws don't have sort of a number of employees required. It's just all employers who operate in this state, have to abide by these laws. So that's sort of an important thing to keep in mind too, is knowing what the state laws require as well as the federal laws. And then the second point here is in the context of reviewing whether there's a policy and procedure in place to address accommodations, is also taking that opportunity to review any existing job descriptions to confirm that they accurately represent the requirements for the job. And if there is, a particular job that requires mandatory vaccination, that's included in the job description. So it's clear up front what the requirements of the job are. And also for the employer to be able to point to later and say, mandatory vaccination is a requirement of this job. We've made that determination. The second step in the accommodation process is reviewing and analyzing requests for an accommodation from, we have the example of a vaccine requirement, but really any COVID-19 related mandate. So the first step in that process is determining whether the particular request falls under the ADA or Title VII. And we've definitely seen that it is not the case that just because someone makes an accommodation request, that the accommodation request actually meets the requirements of the ADA or Title VII. I think we've all sort of experienced in the context of a vaccine mandate specifically, there is definitely personal preference that comes into play as well. And people, maybe not wanting to get the vaccine for a personal reason that has nothing to do with their religion or a medical condition or disability. And if the request is based on that, a personal preference to not have the vaccine, that's not going to be sufficient under the law. And that particular request does not need to be considered for accommodation. And in that context, it's, that's a good opportunity to sort of reiterate what the employer's policy is related to accommodations, and also to reiterate that if it doesn't meet one of these legally protected accommodations, that the vaccination mandate applies and it's going to be required. And if that requirement isn't met, there, may be some disciplinary steps taken. And then I think I noted, go ahead.
Lindsay, I don't know if this is a good time, but, I did want to reiterate that, you're still working within the framework of the disability accommodation law. So keep that in mind as you're dealing with these various accommodation requests in the context of COVID, right? COVID mandates. So, in this context, on this very issue, is that if an employee has a disability that's obvious, you're expected not to inquire into the nature of the condition. In that situation, you'd be looking at how that disability impacts the employee's ability to perform the job and looking at potential accommodations. Where the disability is not obvious, you may be able to probe a little bit further. And then the religious accommodation context is a little bit different framework, which we'll discuss in a bit. But just, there was a question that came in about whether an employee should be placed on unpaid leave as an accommodation. And I think what's important to keep in mind is that the accommodation process typically focuses on finding an accommodation that will allow the employee to remain in his or her existing position and, ideally in the workplace, and then looking at accommodation. So typically you look at whether the employee can perform in the existing position. If that cannot be done as reasonable accommodation being provided, then you look at alternative positions. And then really the last resort is typically placing the employee on an unpaid leave of absence.
And I think that leads really well, Andrew, into the second point here, which is that employees don't need to use any particular verbiage or, make a formal request for an accommodation. It's pretty broad, that an employer has a certain level of responsibility for recognizing when someone is making a request for accommodation. They may not always say, I understand that there is a vaccine mandate and I'm requesting an accommodation based on this. It could be the case that they say to a manager, my doctor said I really shouldn't get the COVID-19 vaccine because of this condition that I have that could, cause me to have a really bad reaction. That would likely be sufficient in the eyes of the EEOC to indicate to the employer that this individual is requesting an accommodation. And the manager would have a responsibility at that point to sort of take the next steps in, making sure that accommodation request gets to who it needs to get to in HR a lot of times. And then, the process will continue from there to determine whether an accommodation can be given and what accommodation can be given. And then, as Andrew mentioned, in the case of a disability, it might be readily apparent, what the issue is. But in the context of COVID-19, I think, that is definitely less the case because I think that it's not completely clear. I know that there are certain medical conditions that have been identified as, problematic related to the vaccine or, potentially return to work if they're more prone to severe sickness. But in the context of COVID-19, it may be a little bit more challenging to make that determination. And I think that leads well into sort of the next step of the accommodation process, which is initiating the interactive process. So in the context of the interactive process, the employer, employee, and then, if it is a disability related request, the healthcare provider, potentially a religious leader, if an employee is making a request based on religious beliefs, sort of all work together to assess the request for accommodation and the type of accommodation that might work for that individual employee. In the case of a request for a disability, An employer can ask for medical documentation to support the medical basis for the request. I think, this, again, the accommodation process is something that, would have been in place to address the need for accommodation outside of COVID-19. So a lot of employers have a standard form already that they use and request that a doctor complete so that they have an understanding of the basis for the request based on disability, as well as what the limitations are for the particular disability. In the case of a religious accommodation, the EEOC has said in the context of COVID-19 that if an employer has an objective basis for questioning either the religious nature of the belief or the sincerity of the belief, the employer would be justified in this circumstance in making a limited factual inquiry and seeking some additional information and supporting information for the particular request. Generally, in the context of requests for accommodation based on religious beliefs, the EEOC has taken a really broad view of that and said that, employers should, for the most part, accept that a religious belief expressed is sincerely held. But in the context of COVID-19, if there is an objective basis to question it, then the employer has some latitude to seek additional supporting information as part of this request for accommodation and the interactive process. The standard here is that the employer and the employee engage in good faith discussions and efforts to come to a determination on the request itself and then what the accommodation should be. And then, the purpose of the discussion is to determine what accommodations may be needed. And then, from there, the employer will determine whether it can actually provide the accommodations that are needed. Neither the...
I'm sorry, Lindsay. I would just add that just like under the existing framework for the disability accommodation laws, the employer is not required to provide the accommodation of the employee's choice. And the employer just needs to identify a reasonable accommodation. So there may be a variety of options available, but I'll leave that. And then we'll go into this a little bit later.
Yep. Yeah, I'm just sort of, touching on some things that Andrew will cover in a little bit more detail later in the presentation as well. But the last point we did want to emphasize is that neither the ADA or Title VII require that requests be made in writing. So an employee might make a verbal request, but we would generally advise that there is some documentation of the request, for the employer to maintain in their record, to be able to refer back to in considering what accommodations can be made. So even if a request is made verbally, it's good to sort of follow up and say, can you complete this form so we can have a better understanding of the specific accommodation request. So the next step, and we call this 4A because it's sort of part of this interactive process step, is determining if accommodation requests would pose a direct threat to the health and safety of employees or others in the workplace. And we've seen this particular issue, come up often in the context of COVID-19. So direct threat has been something that in the context or under the Americans with Disabilities Act is something that is part of the consideration outside of just COVID-19. But, it doesn't come up a lot. It is often not the case that an accommodation request would create a direct threat, but COVID-19 has definitely presented a unique circumstance where, having COVID-19 is seen as a direct threat to the workplace because of the impact of exposure and, the potential outcomes of having COVID-19 for certain people. So on the next slide, we kind of just review the general direct threat assessment, and this would apply similarly in the case of COVID-19. And I would just note here that the EEOC in its guidance has already determined that COVID-19 is a direct threat, but there certainly may be accommodations that address that threat sufficiently so that if the accommodation request is to a vaccine mandate. So the employee is saying, I can't be vaccinated for this reason, that there might also be accommodations that can be implemented to still ensure that they do not present a direct threat in the workplace. And that's the assessment that you're doing here. Direct threat is defined as a significant risk of substantial harm to the health or safety of the individual themselves or to others that can't be eliminated or reduced by a reasonable accommodation. So the two steps in this process, at least initially, are determining whether something is a direct threat. And then if it is a direct threat, determining whether any reasonable accommodation or other safeguards in the work environment, in the case of COVID-19, could reduce or eliminate that threat. Per the EEOC, there are certain things that should be considered in determining whether something is a direct threat. Like I said, the EEOC has determined that COVID-19 itself is a direct threat, but that is a determination that they've made throughout the pandemic. I don't know how that could change going forward, depending on how COVID-19 changes and the threat of COVID-19 changes, but that has been determined to be a direct threat. So the next slide just kind of goes through the second part of this and how to assess whether a reasonable accommodation or other safeguards in the work environment would sufficiently address the potential for the threat. If the assessment demonstrates that an employee with a disability who is not vaccinated would pose a direct threat, then you're looking at, okay, what are the reasonable accommodations? If this employee is someone who can be assigned to remote work, then they wouldn't present a direct threat in the work environment. And that could be an accommodation I give if it does not cause an undue hardship to my company. Is this employee able to wear a mask? If so, then, they could be in the work environment wearing the mask, and that could address any potential that they have to pose a direct threat to other employees or themselves. And then a lot of employers have safeguards in place already to address and try to limit the exposure to COVID-19 and the spread of COVID-19. So if the employer has, enhanced their ventilation, if this particular employee works by themselves and doesn't really have any interaction with other employees or the public, if social distancing is required, then those safeguards should also be considered, as well as any other reasonable accommodations, and how that together would address the threat. And if that together addresses the direct threat, then, the accommodation of not having to get a vaccine per a vaccine mandate would be permitted, and these other things would be put in place to ensure that that particular employee does not create a direct threat in the work environment. And then on the next slide, what we characterize as 4B, and I kind of already talked about this on the last slide, but it's just determining if one or more accommodations or safeguards can eliminate or reduce the direct threat. Next slide. And then after you've kind of gone through all of those steps, you're getting to the point where you can determine whether there's any form of a reasonable accommodation that can be provided in this particular case. And this is an individualized assessment. These steps are going to be a little bit different for every employee. The steps will be the same, but the particular considerations within the steps are going to be different because it is individualized. It's based on the specific information you have about that employee. It's based on the, specific circumstances that would come out of accommodating that employee, particularly depending on their job, the types of tasks they have to perform. So all of that is going to come into play in considering whether there is any form of reasonable accommodation that can be provided to this particular employee. And I just want to emphasize, because I think this point is important, and Andrew already addressed it a couple slides ago, but it does not need to be the case that the accommodation that the employee has specifically asked for is the one that's actually implemented. If there's another type of accommodation that the employer determines is appropriate, then, you know, they could implement that accommodation as opposed to the one that was specifically requested by the employee. And then I touched on this before, but there is the other part of this is the undue hardship assessment. So at step 6, an employer is evaluating whether an accommodation would cause an undue hardship. So once you've determined what the accommodation is, would that accommodation create an undue hardship? And if it would create an undue hardship, then it might be the case that at least that particular accommodation cannot be implemented. Under the ADA, the standard for undue hardship is significant difficulty or expense. That bar is high. You know, it really needs to be the case, and we, I think, rarely find that something will cause an undue hardship under the ADA, because it is such a high bar, and the expectation is that, you know, generally an accommodation can be made, and it's really only narrow circumstances that a court is going to see the significant difficulty or expense situation met. However, under Title VII, the bar for, or the standard for an undue hardship is much lower. Under Title VII, for requests for religious accommodation, an undue hardship exists where it poses more than a de minimis cost or burden. And the analysis there should include considerations, you know, beyond just monetary considerations. It's also what burden this creates on the employer's business and how they're able to run their business. So that more than de minimis cost or burden is a much lower standard than the one you have under the ADA. So it could certainly be the case that an undue hardship is found more often in the case of Title VII and a request for a religious accommodation. An employer can rely on recommendations from the CDC when deciding whether an effective accommodation is available and would not pose an undue hardship. The CDC has been kind of the standard in considering potential accommodations in the work environment and what would address, you know, the particular concern related to COVID-19. And, you know, we certainly suggest that an employer would want to seek input from the employee's supervisor to help determine the feasibility of a particular accommodation and whether, you know, that accommodation would still allow the employee to be able to do the essential functions of their job. And then the last step is notifying the employee of the ultimate determination. So notifying the employee in writing whether their accommodation has been approved or denied. You know, if it is approved, then the employer should explain what particular accommodation has been approved. So, you know, in the case of an employee who is unable to be vaccinated and the employer has a vaccine mandate, if they're approved to telework, then that, you know, the employer would communicate that that is the particular accommodation that they have decided to implement in this case. And if the request is denied, the employer should communicate that as well and document any available alternatives accommodations. You would also be required to evaluate those alternative accommodations before, you know, taking any steps as far as the employment status of the employee. The employer really has to consider all potential alternative accommodations to see if they can, you know, accommodate this request and keep the employee in the work environment. And then the last piece here is just making sure that managers understand that they cannot disclose that the employee is receiving a reasonable accommodation. There's a confidentiality requirement in this case, particularly under the Americans with Disabilities Act, where medical information should not be shared. And so, you know, the manager might know about the reasonable accommodation because they have to be part of implementing it, but it should not be shared beyond the manager or those who have a need to know about the reasonable accommodation. And I will turn it over to Andrew now to talk about religious exemptions, I believe.
Okay, well, thank you, Lindsay. So Lindsay's walked through the general framework for the accommodation process. And so we identified it in steps for the ease of implementation. But as Lindsay mentioned, it's really important to have someone who's trained on the accommodation process, ideally someone in human resources that manages the process, ensures that you've gone through the proper steps of the analysis. And also, because this is such an individualized analysis, it's important that you consult with legal counsel as appropriate. So, unfortunately, and I advise quite a bit on accommodation issues, and I can never give one answer that applies to multiple situations. So there are situations that we can learn from in the past and apply those for future accommodation discussions, but it's so fact intensive. So it does make it a little bit challenging. So, but we've broken this down into two categories for the next part of the discussion. One is about religious exemptions, and the other is for disability exemptions. And so there was a question that came in about whether the direct threat analysis applies to religious accommodation requests. It can. It's a little bit tricky here because direct threat has traditionally been understood in the context of a disability accommodation. But the EEOC has recognized that the employer may take certain steps based on the COVID pandemic. So, for example, excluding employees that may be positive for COVID from the workplace, or screening employees for COVID as they enter the workplace. And that has been analyzed by the EEOC in the direct threat framework. But whether you consider it direct threat or not, you're still looking at whether a reasonable accommodation is possible. But moving on to religious accommodations, that is recognized under Title VII, as well as equivalent state law. And so while the medical exemptions provide the employer the option to request documentation from healthcare providers, the religious exemptions are quite a bit trickier, and there really isn't the precedent like there is for disability accommodation requests for employers receiving those, like we've had during the COVID pandemic. So it's required quite a bit of kind of getting up to speed on this. And so for religious accommodations, there's often no verifiable basis for the religious objection to a mandatory vaccination or whatever other accommodation is being requested. So moving to the next slide, wanted to discuss some of the considerations here. So it is, before you even get into analysis about whether you can provide a reasonable accommodation, whether there's an undue hardship, you must determine whether the employee has a religious objection that's based on a sincerely held religious belief that prevents receiving the vaccine or supports whatever other accommodation request is being made. And the employee is not required to cite a recognized religion or religious tenet. So it can be a very generalized assertion of a religious belief that can be challenging for employers to wade into. Unfortunately, the EEOC didn't do employers any favor in their guidance. And so the guidance on COVID-19 has stated that employers should ordinarily assume that an employee's religious accommodation request is based on a sincerely held religious belief. And so it's created this conundrum. So if you inquire too much, you're going to get enough of a detail that would support potentially a religious accommodation request, and really create some obstacles for an employer in challenging the request just based on the stated religious belief alone. There is an exception to this assumption that the EEOC has created through its guidance, and that's if the employer is aware of facts that would call into question the sincerity of the employee's claimed belief. I have not seen that come up very often. We do give one example. If the employee only recently adopted the stated belief, or the employee has previously received other vaccinations, but now is objecting to the COVID vaccine, you may be able to inquire why the employee now has a different position. And you may request additional information to support the claimed exemption. So moving to the next slide, Okay, I'm going to walk through, as part of this analysis, what is a sincerely held religious belief. To qualify, the employee must demonstrate the sincerely held religious belief that prohibits the receiving of the vaccine or supports another accommodation request. And the belief must be religious rather than secular or scientific in nature. It can't just be a personal belief that the employee has. There is no clear definition of religion. It is generally accepted that religion is based on beliefs that address fundamental questions about the meaning of life, humankind's nature, its place in the universe, and the general exercise of faith. So you can see how murky this is and how challenging it is for an employer to challenge whether the employee actually has a belief, a sincerely held belief that is religious in nature. An employee's political, sociological, personal, or philosophical views do not qualify as religious beliefs. So examples that we've given is the ways of living, such as veganism, pacifism, or minimalism, do not provide a religious exemption basis. And during the pandemic, employees were educating themselves on through various different means on the internet and otherwise about how to state that religiously held belief. And that has created, issues for an employer in challenging that was in fact bona fide. So moving to the next slide. Okay. We do. I think we can gloss over some of this, and I will get into just general recommendations for how to address these religious accommodation requests. But what we give some examples of what is not a religiously or sincerely held religious belief, and that you may request additional information under certain circumstances where it's not clear, what the religious belief is. You may request additional information about the employee's belief system, the nature of tenets of their assertive beliefs, how they follow the practice or belief, review written religious materials describing the belief or practice, and obtain a supporting statement from the religious leader or another member of the community who's familiar with the belief system that's being asserted. That all being said, I recommend that in these situations you have a form that you use that clearly states what information is being requested. You want to avoid probing too far and requesting more information than you actually need, and that could serve as the basis for a potential retaliation or discrimination claim at that juncture or a future one. Moving to the next slide. Okay. And here are some examples of what is not a sincerely held religious belief. That is a fear of possible side effects from immunization, a desire to live a healthy or pure lifestyle, opposition to a vaccine due to veganism, as I mentioned, a belief that the vaccine will do more harm than good, or distrust in the government or the science supporting vaccination. And now it really just depends on how the employee articulates that sincerely held religious belief, and that's going to affect whether you probe further and ask for any supporting information. And then, moving on, the religious exemption inquiries, you need to probe carefully, as I mentioned, since you may obtain information that ultimately could support a retaliation claim and might ultimately not be that helpful in your assessment. So, we do recommend that you have trained HR personnel engaged in these sensitive discussions, and ideally using forms that could streamline and minimize what information you request. And that it's really important that you treat the exemption request consistently, since that could open you up to a discrimination claim, and create an argument that your decision ultimately is pretextual. So you want to have a clear framework for how you address this and be consistent on how you implement. You should encourage employees to communicate with their supervisors on this, and that would be stated in your policy. and in communications with employees. And you want to handle these requests discreetly and timely, treat the information as confidential. And as bullet 2, create a template of questions, ideally, that you can either work off of when the HR individual communicates with the employee, or it could be something provided to the employee to then complete. And you can have, for the inquiries, you could have something, as simple as a question about whether the claimed religion prohibits the COVID vaccine or vaccinations generally, if that is the concern, if that's the issue at hand. And then moving on, we give some examples of misleading claims, and I'm going to gloss over those because we don't want to suggest that because a claim may be misleading, you can just dismiss the employee's concern out of hand. You do want to give it your full attention and review. But there are claims that, for example, claims that their faith prohibits COVID-19 vaccination because the vaccines are composed of cells of aborted fetuses. And let's move to the next slide. And then there's been, claims about certain religious institutions prohibits the vaccine if that is the issue. And there was a statement by Pope Francis urging all people to take the COVID-19 vaccine for the good of all people. There has also been questions in the Jewish faith about vaccinations, and while there is no singular authority on this question, the Jewish faith is commonly accepted Jewish precept that guarding one's health is a mitzvah. Is a good deed. The command taking the COVID-19 vaccine, and so this is all as a backdrop. But I'd like to move on to, if you accept that the employee has a bona fide religious basis for the exemption request, what action do you take? And many times I've found you'll be in a position where you don't have enough information or can't obtain enough information to really challenge the religious accommodation request as a bona fide request, but instead your focus is really on what is the reasonable accommodation that can be provided, if one can even be provided. So you need to engage in this interactive process, just like you would with a disability accommodation request. And that would involve having a timely dialogue with the employee, reviewing their request, and then determining what accommodation should be provided. So in the situation of a vaccination, and this has all been largely built around for a presentation, the vaccination issue, but it's much broader. It also involves a return to work. And so in the vaccination context, you will, if the employee states that for religious reasons he or she cannot be vaccinated, and you determine that there's a bona fide exemption, you're moving on in your inquiry and assessing whether an accommodation should be provided. And so that will be highly fact intensive, will determine on the nature of the workplace. And so if you have an employee that's in an office job and doesn't have personal contact with customers or others in the workplace, or if that's not essential for the job, you may be looking at teleworking as an accommodation. You may have other positions where there is a need to interface with coworkers or the general public. I think about hospitality settings where you cannot have certain employees teleworking. And in that situation, you would look at what accommodations can be provided. And so you are not required to provide the accommodation of the employee's choice, but you are required to provide a reasonable accommodation. You do look at undue hardship based on the framework that Lindsay mentioned. And there's a number of different options in the context of a vaccination mandate. You could have employees wearing face coverings. So if an employee needs to be in the workplace unvaccinated, you may require that employee to wear a face covering. I know during the point of the pandemic when we had very high case count, we had employees so in some workplaces that were being required to wear N95 respirators if they had contact with the general public, or at least a face covering. You may be able to transfer the employee to another position or have the employee work in a more remote location in the workplace. It may be if the employee has contact, or say they're in a sales job where they have to interface with the public, that you might not be able to do that. So it's just, as I mentioned, highly fact intensive. Moving on, let's talk a little bit about medical exemptions. So there's a little bit of a different framework here where the disability is not obvious. You may ask for appropriate information from the employee or the employee's healthcare provider about the disability. You certainly want to inquire about the nature of the nature of the impairment. That really depends on whether the impairment is obvious. And so if you, as an example, if you know that an employee has a visual disability, then there wouldn't be a reason to inquire into the nature of it if it's apparent already, but there's other situations where you would. And then you certainly have a right to inquire into the duration of the need of the accommodation and the extent to which the impairment impacts the employee's ability to perform the job. So in a vaccination context, how it impacts the vaccination requirement. And there may be circumstances where you need to consult with the employee's healthcare provider. And typically the inquiry would relate to the nature or how the impairment impacts the employee's ability to do the job. And so if you are going to interact with the healthcare provider, you will need a release from the employee for HIPAA reasons and for medical privacy reasons. And you may need to, let me just say that how I would typically recommend you do this is to have that communication writing with the provider, so it's clear specifically what you're asking for and that it's within certain limited bounds, so that if you do obtain information beyond the scope, it's clear that you have not sought that information. Okay, and then moving to the next slide. Okay, and then the analysis for whether the employee has a disability is whether the condition impairs or substantially limits the employee's major life activity. And there's a variety of major life activities. It could be working, breathing, etc. And you do need to keep in mind that certain state laws may have a lower threshold for what a disability is, and that you want to keep that in mind. And under the ADA, there is a list of medical conditions that automatically qualify as disabilities. And also keep in mind that an employee who is pregnant may qualify for a pregnancy-related or disability-related accommodation. And so, moving on. And so, the disability analysis is individualized as well in determining whether the employee has a disability. And it may be, this analysis really came from much of the advice earlier on in the pandemic when employees had COVID and what type of accommodations to provide. I think we can just discuss in a more general sense, but if an employee has COVID and the symptoms are resolved early, that might not be a disability, but there could be situations with long-term side effects that could qualify as a disability. Let's move on to the next slide. Okay, and so before we get into employer incentives, when an employee has a disability that you recognize as one, then you're looking at what type of reasonable accommodation can be provided. And so there were employee disability accommodation requests in connection with the vaccine. And that typically related to confirming whether the employee for health reasons could not be vaccinated, or whether there was an alternative vaccine that was required. I mean, you could have a situation where you have an employee, this has happened, but very limited numbers who have had side effects to the vaccine. And so, as a result of that one dose, have not been able to take the vaccine again, and that may be a medical accommodation issue. And in other contexts, you may have employees in the return to work context who, as you're returning employees back to work, may ask for an accommodation in the form of teleworking because they have some sort of disability. It may be a condition that can lead to severe side effects from COVID. It could be from diabetes, it could be a heart condition. There's a recognized list. In that situation, you would go through a similar analysis of looking at what sort of accommodation you can provide. Is there a way to restructure the work environment so the employee can come back to the workplace, or is there the ability to have the employee off work, teleworking, and continuing to perform the job? We do have this slide that addresses employer incentives. An employer may provide certain incentives to employees for vaccination. We saw many businesses doing the pandemic, preferring the carrot over the stick. And in those situations, the EEOC has recognized that an employer may provide incentives for employees who receive the vaccine on their own, and that incentive may be in the form of cash payments or otherwise. And where the employer receives the vaccine from the employer directly, the incentives may be offered as long as the incentive is not so substantial as to be coercive. And then employers may not offer incentives for employees' family members to receive the vaccine. That is a major exception. So moving on. Okay, and then I think a really important point is confidentiality, and this is consistent with the disability laws, is that if you have an accommodation request, whether it be related to the vaccine or some of the other issue, you are required to maintain that information in confidence on a limited need-to-know basis, so that would typically be confined to human resources and the manager that needs to implement the accommodation. And then under state laws, there may be additional requirements for how you safeguard that confidential information. So the last slide, and I think we've made perfect time, so that will give us the ability to answer some of your questions. Retaliation is an important consideration. And although this is under the disability slide, it pertains to religious accommodation requests as well. And it's important to keep in mind that there are laws prohibiting retaliation for employees that have engaged in protected activity. And that could involve filing a claim, of course. It could be a charge of discrimination, making a complaint to a supervisor, but it could also be the mere fact of requesting an accommodation, regardless of whether the request is granted or denied. So where you have an employee that has made an accommodation request, just be cognizant of the potential for retaliation, at least to be alleged. And so that if you have an adverse employment action that's taken after the fact, that's entirely independent of the accommodation request, you want to ensure that you verify that you have sufficient support documentation of that request to avoid any potential retaliation claim, and really assess, for retaliation, you're often looking at how close in time the adverse employment action is to the protected activity, and then also what sort of support you have for that adverse employment action that would offset any potential claim of retaliation. So we are now at a point where we can answer some questions, and let's wade through some of these. Actually, Lindsay, did you see one that you'd like to answer?
So one of the questions that I saw, and I know we have quite a bit, so I'm sorry if I'm just pulling a random one sort of out of order, but we'll try to get through at least a few of them. So one that I saw was, do you have to offer an applicant an option to apply for an accommodation, or can you state that COVID vaccination is a requirement of employment? And I think that that's a really good question. You know, it does apply to applicants as well, the need to consider an accommodation if requested. And I think, you know, you can certainly convey that if vaccination is a requirement of the particular position they're applying for, or if it's just required, you know, for the particular location anyway, you can certainly tell the applicant that it is required. You should tell the applicant it is required. That's part of the reason that we also suggest, you know, if there is a COVID-19 vaccine mandate, that is included in the job description, so that it's clear up front that this is a requirement, so that if the applicant does need an accommodation, they know to mention that, to indicate that, you know, to somehow inform the employer that they would need an accommodation to the vaccination mandate. It is the responsibility of the applicant to make the request. But again, there isn't sort of that specific verbiage that needs to be used. If, you know, during an interview, the applicant mentions, you know, I saw that it's required to have a COVID-19 vaccination for this position, but, you know, I have a medical condition that prohibits me from being able to get a vaccination, then, you know, if you do ultimately determine that they are the person best qualified for this position, that there needs to be an accommodation made. And that's sort of how the process would work.
And there was one question: if the supporting document surrounding a religious exemption comes from the Church of the Internet, in quotes, can the employer require the employee to provide additional information? And I would say certainly so. I mean, the analysis is whether the beliefs address fundamental questions about the meaning of life, humankind's nature, and its place in the universe, and the general exercise of faith. And the Church of the Internet does not indicate that. And so that could be a further point of inquiry. And so unfortunately, you can get in this, this loop where you ask for the information, they give you a little bit more, there's an ambiguity, you ask for more, and then they finally give you enough where you have to conclude that they have a basis for the request. And so there's just a tactical or practical question about how far to probe in some of these cases.
I saw another question about, and this is related to our discussion today. If an employer requires vaccine to do work and the employee has an adverse reaction, can the employer be held liable for the injury? If the vaccination is mandated for the job, then if there's an adverse reaction, I believe that's generally going to be something covered by workers' comp. So, you know, that would be the route for any need for recovery related to medical treatment or something like that. But I believe that the employer would be protected by the workers' comp insurance.
And there was one question: can you talk about the steps an employer can take to challenge a physician note about taking the vaccine? We're seeing a lot more dubious medical exemptions by sympathetic docs than normal in this context. I mean, you're right. There are doctors that may, I mean, this is more common in the non-COVID context, where you have an employee that has some sort of medical impairment and they get some blanket request from a doctor supporting the request. You know, it's potentially without any kind of real insight into what the job entails. And so, you know, one way to approach this, you just have to, you know, this is an area where I certainly, you know, recommend consulting with counsel and having them working with you on this. One way that you can do this is you can, you know, if it's specific to the job, outside the, it might be outside of the vaccine context, but if you can provide the doctor a job description or some detail on the job, and then provide certain really tailored questions about about what the doctor's conclusion is, and they can be leading in such a way that you're more likely to get a response that may be actually helpful for you. But it's, it can go either way. You can have this letter to the doctor and get some sort of ambiguous answer that's not helpful ultimately. So I wouldn't do that in many circumstances. And then I think there's some other questions here. Lindsay, did you see anything else?
I'm trying to read through a bunch now.
Okay.
And like I said, we won't be able to get to everyone's questions, so we can certainly, follow up separately as well if we're not able to get to your question. I did see one, and I think this is interesting, and it has actually come up for us. We've I think dealt with a similar issue. Whether a person who requests an accommodation from a vaccine mandate based on breastfeeding, whether that would be considered under the Americans with Disabilities Act as a basis for an accommodation. And I think that this is sort of a gray area right now. Under the Americans with Disabilities Act, it really should be that the basis for the request for an accommodation is the individual employee's disability or other medical need for an accommodation. And breastfeeding would not necessarily fall into that category. Unless, a doctor determines that for some reason, that particular individual who is nursing might be at some risk if they get the COVID-19 vaccine themselves. However, I do think, to the extent that there is a potential accommodation, like I said, this is sort of a gray area. It doesn't squarely fall under the ADA, but we definitely, are cognizant of potential complaints related to discrimination based on pregnancy or the after effects of pregnancy related to pregnancy. So I think it is helpful if someone makes a request like that to, at least follow up, maybe get some additional information about the basis for their request for an accommodation. If they can get a doctor's note, I think, you would want to get medical documentation still to support that request for an accommodation. And have them provide that, and then you could move forward with an accommodation based on the medical documentation you receive from the employee. And Andrew, I don't know if you have anything else to add there.
No, I did. There was one question that says that the question was, hasn't the EEOC said that someone can say their particular Catholic beliefs prohibit taking the vaccine, notwithstanding the Pope's statements? And so, I was giving those examples of different religions where there is not a view against vaccinations, despite that they may be cited. But even then, I mean, you could have an employee that states that because of his or her own views of Catholicism based on the denomination in question, that a vaccination would not be appropriate. And so that really would require probing further. It could be that it's a particular denomination. It's a tricky question, but I don't think the EEOC has waded so far as to kind of parse this out between the Pope's statement and what others within the religion may assert.
I think we could probably do a couple more, and then we should probably conclude the webinar. But one that I saw during the presentation is whether an unpaid leave of absence is an acceptable accommodation to offer. And I think, again, going back to this idea of it being an individualized assessment and sort of considering all of the possible accommodations that are available to the employer and what, they'd be able to provide this particular employee. It is, I think, I think we talked about this a little bit, it is a form of an accommodation. And, certainly if the employer considers other available options, and this is determined to be, the reasonable accommodation that is most appropriate to offer in this circumstance, then, then the employer can proceed with doing so. You do want to make sure that you are sort of documenting the interactive process and the assessment of the available accommodations to support the ultimate determination made. But that is an available form of accommodation and may be appropriate depending on the circumstances for that individual employee and the specific needs that they have based on either their disability or religious beliefs.
There was another good question. Do these guidelines apply in jurisdictions like New York City that have a vaccine mandate for businesses? So, many jurisdictions are kind of removing the vaccine mandate. But to the extent there is a governmental entity with a vaccine mandate that applies to your business, it would really be the same analysis about, you would still be looking at whether there is a basis for religious or medical exemption. So you go through a very similar analysis. I think with that, we'll conclude the webinar. Certainly, feel free to reach out to us individually with any questions you have. This is an area where we have advised employers consistently throughout the pandemic, and it's certainly been novel and different and created many challenges for you all. And we recognize that.
And just to add, I think this is COVID-19 and how the pandemic has progressed has, been changing all throughout the past couple of years. And I'm sure things will continue to change, and, we may continue to see surges in COVID-19 periodically, or, it might be the case that symptoms over time, tend to be more minor. And I think that these changes are important to keep in mind because, as these changes occur, the guidance changes, from the CDC, from the EEOC, from these important government bodies that are sort of setting the standard for what employers need to be doing, OSHA as well. So it's important to sort of keep in mind as the pandemic continues to change and shift, and things continue to shift, the guidance will change and shift as well. So you just want to make sure you stay on top of that and incorporate the new guidance into your policies and practices.
Okay, and I would just add that that's a really good point. And there has been a recognition of direct threat based on the case count for COVID in the community and the prospect for serious illness. But as COVID becomes endemic, there could be a view by the EEOC and other agencies that there no longer is a direct threat, and that would affect the remedies that are available by an employer. And I think with that, we will conclude the webinar, and we appreciate you participating with us.
Thanks, everyone.